Hi, folks. Denise Howell here. And next up on This Week in Law, Mike Keyes and Lisa Borodkin are with me. We'll look at this week's Supreme Court decisions on internet sales taxes and cell tower information. We'll check in with what's going on with net neutrality. Lawyers will sing about fur tape, and we'll look into what's going on with that wacky Gen Z, all next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, Matt Curtis, and Mike Keyes. Episode 427, recorded June 22nd, 2018. World War Gen Z. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. Welcome. We're so glad you're here. We are so excited to do the show today. The Supreme Court has been very busy, so we're going to talk about some of what it has been up to and a lot of important developments at the intersection of law and technology. Per usual, we have a wonderful group of folks together to do this with today. My co-host, Mike Keyes, is back. Hello, Mike.
Hello, Denise. Great to see you and great to be back.
Wonderful to see you too. It has been too long. We have been having some crazy spacey shows in your absence. And thank you for loaning us your colleague, Stefan. He was great.
Oh, it was a great show. I was able to pick up later that evening. And he did a great job, and it was a really fun show, entertaining.
Yes, it was. And also joining us is one of our favorite semi-regulars here at This Week in Law, Lisa Borodkin, who is a lawyer with the Zoller Law Group in Los Angeles. Hello, Lisa. Welcome back.
Hello, Denise. Hello, This Week in Law. Nice to meet you, Kevin. And greetings from El Segundo, the future capital of the Los Angeles news community.
Oh, why is that?
If you haven't heard, the New York Times is relocating their headquarters to El Segundo.
Really?
Oh, yeah.
I did not know
fake
this.
News. Yeah,
that's not fake news.
Happening. Yeah, it's not fake news.
That's cool. New York Times on the beach.
Yeah.
Not bad. Nice
Not
move.
the New York Times, the LA Times. I
LA Times. Yeah, I was going to say that
would be a big showstopper. New York Times moving to El Segundo for sure.
Yeah.
Yeah. Well, good for the LA Times. Yes, they needed to have a better view for sure. And that puts them closer to the Boring Company is somewhere up there as well.
That's right.
Yeah.
Kind of a nice aerospace corridor we have here. But yeah, anyway, I'm excited for the show and glad to be back.
Wonderful to have you back. All right. Well, I mentioned that the Supreme Court has been busy. The Supreme Court was busy even this morning. The much awaited Carpenter decision has come out. So let's start with that. We've talked about this case before on This Week in Law. It has at its crux whether law enforcement has to get a warrant in order to get cell site location data to use to charge someone and use as evidence in prosecuting someone for a crime. And just this morning, the United States Supreme Court has issued its decision in this important case. And in a very close 5-4 decision, the court decided, yes, indeed, a warrant is required in order to maintain or obtain, that kind of data from a cellular company. So this case involved some folks that were involved, hilariously enough, in stealing cell phones. They were going around hitting Radio Shacks and other stores. The police apprehended one of the lower people on the criminal enterprise, who then pointed fingers at the ringleader, Mr. Carpenter. And in order to obtain evidence against Mr. Carpenter, law enforcement obtained somewhere upwards of 120 days of his cell site location data, which pinpointed his location within half a mile to 2 miles of accuracy every time he connected his cell phone, connected with a cellular tower as he moved around. And lo and behold, these locations were pretty close to where the crimes were taking place, and that was used at his trial, and he was convicted. Appeals ensued. The Supreme Court got involved, and this morning we have a decision with a majority by Justice Roberts and 4 different dissents by the dissenting justices, deciding ultimately that a warrant and probable cause, which is necessary to get such a warrant, will be required in future to get this kind of data for law enforcement. In most cases, there are a couple of narrow exceptions, which we will discuss. So let's start with you, Mike. Were you surprised by today's decision?
I kind of was, not so much in the decision itself. I mean, I haven't had a chance to really dive in. It's about 119 pages, all the various opinions out there. But the thing that struck me kind of right off the bat, we've talked before about Justice Gorsuch and his opinions when he was a circuit court judge. He was a fairly, I'd say, protective of Fourth Amendment rights. We talked about a couple of opinions in particular that he authored as a circuit court judge. Kind of surprised to see him in the dissent here with Chief Justice Roberts writing for the majority. So right off the bat, that kind of surprised me given what we've talked about and discussed with respect to Gorsuch previously. But always fascinating this time of year to see these big decisions come out. This is obviously a very significant one for law enforcement officers, and it's really significant. And again, another 5-4 decision just shows how closely divided this court is. Pretty fascinating stuff.
It is really fascinating stuff. I do think it's interesting that the court here was held to a higher, or the court is going to hold law enforcement to a higher standard than they had to use in this case. In this case, they didn't just go willy-nilly to the cellular provider and say, turn over your data. They did have legal authority behind them. They used the Stored Communications Act as their foundation for saying we have authority to obtain this data for you. But that is a lower standard and did not require a judge to vet the law enforcement claim that they needed the evidence as does a warrant requiring probable cause. Probable cause basically means that the evidence that the law enforcement officers are seeking is likely to provide evidence that a crime took place. So they have a fairly, it's not that hard to get a warrant, but it's a higher standard to meet than the one they did in this case. And what seemed to be really important to Chief Justice Roberts writing for the majority here was, again, this recognition, and we've seen this pattern in a few different cases from the Supreme Court over the last several years, this recognition that technology has fundamentally changed the way we need to think about the Fourth Amendment and the way that our lives work now. I mean, they basically acknowledged that a cell phone is a necessity of modern life and we're all carrying them around, and yet we have not forfeited our expectations of privacy merely because of the way these devices that we're carrying work. So I think that's an important note for the court to hit here. What did you think, Lisa?
Well, I'm just reading the headlines. Like Mike, I haven't worked my way through the reasoning of the entire opinion, but my reaction is generally one of relief, but also feeling like it was a close call, no pun intended. It's very important that the Supreme Court interprets the Fourth Amendment and expectations of privacy in light of current prevailing norms. And the more that we're dependent on our mobile devices, the more important it is to keep a balancing of certain safeguards. I mean, in reading some of the other news stories in the rundown, it strikes me that just requiring a warrant to obtain physical location records is not a tremendously burdensome standard. I mean, all kinds of federal judges are ordering all kinds of things that have just monumental impacts on large swaths of our population. So I feel a sense of relief that I think that this is the right outcome, and I do look forward to reading the entire opinion.
Yes, the opinion, we should say, just came out this morning, and as Mike pointed out, is really lengthy. So we're attempting to pass along our thoughts to you without the benefit of diving into it in any great detail. We're simply thankful for the people who have done so quickly this morning and have already published their thoughts. And we just wanted to be able to let you know that this long-awaited decision has come out, and that it has been in line with some other recent decisions of the Supreme Court that seem to be recognizing the importance of maintaining Fourth Amendment standards in the era of things like GPS trackers that can be applied to your car and cell phones that we all carry around. I had just read an article yesterday that I thought was really sort of timely based on the decision coming out today. And in fact, we have some other stories that we'll talk about in a different context in a bit in the show, talking about Generation Z, which I guess is what we're calling today's teenagers, 13 to 23-year-olds wandering about in the world today, and the way that their devices are a part of their lives, which is, I think we're all welded to our devices, or we think we are. We don't function very well without them. But this new generation has never functioned at all without them from the time that they were, maybe 10 to 12 years old, through what will be the rest of their lives. And this piece at Global News in Canada sort of pushes back on the notion that this new generation is addicted to their devices. And instead, one of the folks quoted in this piece says, it's not an addiction, it's an extension of themselves. Are you addicted to your right hand? And having one of these in my household, I can tell you that truly is the experience that I see my son and his cohorts having. That it's not so much, they can't or won't put the devices down. They simply see it as such a resource for their lives that why would they? It's literally like cutting off an appendage that you need to function well in the world. So I think that recognition, I don't know if I don't think the Supreme Court probably read this piece, but I think that sort of theme definitely comes through in the analysis here that, it's not so much a choice to be using these tools, and nobody certainly chooses how they function, and the fact that whenever they connect to a cell tower, there's a record of your location. So it seems like that played a pivotal role in the analysis here. Another thing that I thought was quite interesting was that Professor Oren Kerr, who is one of the great legal scholars of our era here, weighed in on the side of the government and submitted a brief that the dissenters found compelling, but that Chief Justice Roberts said, I see what you're saying, but not going to agree with you. And it had to do with reasonable expectations of privacy. When you walk to the store, your neighbors can see you walking to the store. People you don't know can see you, and they can be called as witnesses to say, yes, that this person was in this location at this time. But Chief Justice Roberts wasn't ready to lump cellular companies and their towers into that kind of bucket, and said, no neighbor is as vigilant as these cell towers are, and there's no real appreciation among the general public of how closely they're being tracked. So to get at that data does really thwart how people think that their privacy interests are being represented in the world. Mike, do you have any other thoughts?
No, I mean, I agree that analogy just doesn't hold. I mean, even the nosiest of neighbors aren't going to be on 24/7, able to track and monitor your whereabouts, no matter how vigilant or diligent those neighbors are. So yeah, I agree with Justice Roberts. That just doesn't really hold water for me. I think this is it's a significant decision. Obviously, I do wonder about how big of an impact from a day-to-day perspective with respect to law enforcement it is. As Lisa was pointing out, look, you can get a warrant. You have to show probable cause. You don't have to show. It's not a tremendous showing that you have to make. And so it seems like this is more or less maybe a little bit more time consuming for law enforcement officers, but I'm not sure that other than that, it's going to be a significant burden. And it's a pretty significant victory for data privacy advocates and others. So those are my thoughts.
Right. It might be worthwhile to contrast the two standards, the ones that the officers used here under the Stored Communications Act required them to demonstrate specific and articulable facts showing there are reasonable grounds to believe that electronic data being sought is relevant to an ongoing criminal investigation. So that might sound a lot like, oh, well, isn't that what you have to show to get a warrant anyway? No, to get a warrant, you have to show facts that support an objective belief that the person to be arrested has committed a crime. So it's beyond just helpful to the investigation. It's that what you're going to find out will help cement, and there's objective, reasonable basis to think this will help cement that they committed a crime. Or that the place or the item to be searched bears evidence of a crime. And a judge has to vet that and agree, yes, there's probable cause, and yes, you can go get this stuff. So warrants issue all the time. They're not, it's not a terribly hard standard to meet, and law enforcement is certainly used to doing it in other contexts. So I don't see this as a huge, thwart or roadblock to investigations. It's a check in the process. But
yeah,
go ahead, Lisa.
Remember how much trouble they had getting a warrant in The Wire? And it's a really big deal if the government wants to start wiretapping and listening in to your audio conversations. So to just have a different standard for basically following your physical whereabouts around, I mean, it doesn't seem that it would fit into existing Fourth Amendment law that easily to create such an exception. I was just thinking of how this fits with your analogy of the neighbor and thinking about the old plain sight doctrine. I mean, if it's in plain sight, sure, that can start leading to probable cause, but it is different. Something like using technology that everyone depends on for other day-to-day necessities to then conduct surveillance with a lower level of scrutiny than they would need to listen in on your actual conversations, for example.
Right. So what people might be wondering is, so if this evidence was bad and there was supposed to be a warrant and there wasn't one, does that mean this criminal who was turned in by his underlings and going around hitting Radio Shacks, is he going to be let go? And it doesn't look like that will be the case at all. Timothy Carpenter was the suspect in question here, because there is a different part of the Fourth Amendment that says if law enforcement obtained the evidence believing that they were acting according to legal authority, it's still admissible, even if the law changes afterward. So this isn't going to go back and undo necessarily his conviction, which, it's sort of bittersweet, I guess, to win your Supreme Court case and have it mean that you're still going to do your time. But I have I don't know all the context of who came in and represented Timothy Carpenter and why, but it really seems like maybe he got legal representation here from someone who wanted to take this case to the Supreme Court if possible and make this kind of precedent, not necessarily because Timothy needed to be set free. So we'll have to see exactly what happens with him after the fact. Any final thoughts, Mike?
Nothing here. I think you've exhausted my thoughts on this one.
All righty then. Lisa, anything you want to add?
No, I look forward to reading the actual opinion.
Yes, as do we all. And I bet the dissents are going to be really interesting too. 4 separate justices giving their different thoughts on it. All right, that's not the only thing. We're down here at the end of the Supreme Court term. They have a bunch of things that they need to get done so they can conclude the term that started in October. The other case that came out yesterday undid a case that we've talked about on the show before called Quinn, TWiL. And this is the case that involved whether online retailers have to charge sales tax. And the decision this week, again, another 5-4 decision from the Supreme Court that just came out yesterday, says that states can make online businesses collect sales taxes even if they have zero physical presence in that state. That's been kind of the kicker for a while and the confusion about this. So states can require online retailers now to charge sales tax in their states. This isn't really going to impact the major players because they have been voluntarily complying. They caved to state pressure some time ago and collecting sales taxes voluntarily, even though this law was unsettled in states like California and Colorado, et cetera, states that have gone to them and said, hey, you need to do this. Because the default, if the retailer doesn't do it, is that the purchaser is supposed to keep track and pay those sales taxes with their tax returns. And that is honored far more in the breach than in the keeping. So, Amazon and others are well positioned to deal with this Supreme Court decision, but it's the smaller players, the very small online retailers targeting niche audiences and trying to expand to be an Amazon someday, maybe, or just to be successful, who are really going to have to know, okay, different sales taxes apply in all the 50 states. And this is going to be a large undertaking for a small business or even, a small mom and pop kind of shop. So my prediction about this is that the small businesses are going to band together and convince their elected representatives that we need some way to make it easier for them. We need some sort of uniformity that gets around and runs the fact that complying with each individual state sales tax law is going to be pretty onerous. What do you think, Mike?
Yeah, this is a very significant decision for smaller players in the market for the exact reason that you're mentioning. I think that prediction is a good one. In order for them to really compete in the marketplace, this is going to be a tremendous burden. You can imagine a small mom and pop shop that doesn't have any physical presence in 49 of the 50 states. Now they're subject, but still sell their goods over the internet into those states. Now they're going to be subject to collecting sales tax on all of those sales and remitting it to the various state agencies. It's just what a headache and what a financial burden. So, something's something's got to give. It's either in the short term they're just not going to do it to a large extent, or at some point they're going to have to try to force a change here to make it a bit more sensible. Because I think it was Justice Roberts in his dissent. It was Justice Kennedy in the majority in this one, Roberts in the dissent. He was saying, look, this is really going to adversely affect in a very significant negative way all of these small retailers that are out there trying to, sell their beads and other things, as Justice Roberts said. So pretty, this has got to be pretty upsetting to all those small retailers.
Yeah. And backing off my prediction somewhat, it's one of those, very primary things that are reserved to the states is how much tax they're going to charge for items sold to their residents, and for the federal government to be able to come in and say, thou shalt charge 6% to make everything uniform. That's not going to fly very well, but they've got to do something. There's got to be a way to make this not the burden that we think that it is likely to be, and Justice Roberts thinks that it's likely to be. Lisa, do you see any light at the end of this tunnel?
Sure. If I'm going to take the contrary position, first of all, physical retailers have different opportunities to report and comply with state taxation. If you've ever heard of a cash discount, you know what I'm talking about. So in a way, it could be balanced against that. And, my tax professor used to say, tax policy is social policy. So if you want to encourage and incentivize local physical businesses in communities, and you want to sort of protect them from unfair competition from large online conglomerates, I guess this is one way of thinking about it. Same with states who need revenues and are trying to collect tax. And, it does sound difficult, but it probably creates an economic opportunity for developers to sell solutions to small businesses to help comply with these new state regulations. The online distributors like Amazon and Etsy might not benefit in the long term, but I think we've seen a lot of revolutions from businesses like Square and other vendors who create tools to allow individuals to take credit cards. So I don't know that it necessarily is an unsolvable problem. It's just that the money has to be reallocated. So I think those are some potential upsides.
Yeah, that's a really good point. And let me ask you what you meant by your cash discount remark. Wouldn't it mean that if you're getting a cash discount that the retailer is simply giving you a better price for cash because the cash is not something that is traceable necessarily, that if they don't want to pay taxes on it, there's not going to be bookkeeping that says they have to? Is that
well, that's between the retailer and the state franchise tax board. But whether it's a cash discount because they're not paying a credit card processing fee or something else, my point is that there could be economies and efficiency from having a face-to-face transaction, and that it actually may more properly allocate the burdens and benefits of different means of dealing. This decision kind of reminds me of a recalibration of economic power. In the state of California, we had a recent very significant employment area decision that is going to impact businesses like Amazon and Uber that sort of compete by disrupting traditional industries, because in the state of California, the Supreme Court has significantly redefined the definition of an employee versus an independent contractor, meaning you can't just decentralize your operations and then not pay employment taxes and all the other types of unemployment insurance contributions that a physical store or restaurant has to pay. And, they've been suffering a lot because when Amazon, for example, delivers groceries to you, then you're not really, as a customer, bearing the cost of the employees that would need to ring you up in the store, for example. And Amazon would have treated the truck driver as an independent contractor. So in the state of California, they've kind of rebalanced that economic power. And so I think we're going to see some really interesting realignments between that in the labor and employment area in California anyway, and now with this state tax decision from the Supreme Court.
Yeah, that's a really good point and thing to highlight and raise. Mike, how do you think that the cryptocurrency usage and markets are going to be affected by this decision? If we all start paying with Bitcoin, does that somehow end run this, enable people to dodge the requirement to pay state tax that this decision has handed down?
Oh, I think that would significantly reduce the ability of states to regulate and collect the tax. No question about it. Yeah, I think you raise a really interesting point, which is a very practical one. How are these states going to go about collecting these state taxes from these small retailers? I mean, how do you go about tracking that? It seems to me there's a whole host of issues that states are going to have to grapple with in terms of making good on this decision. As I think you were pointing out earlier, Denise, that given certain transactions, like if I go into Oregon, for example, and I purchase something and I bring it back into Washington, depending on what the good is, I'm supposed to pay excise tax here in Washington and self-report that. I don't think we're going to have a bunch of online retailers that are going to be doing a bunch of self-reporting. I think they're going to it's going to be hard for states to implement some sort of enforcement mechanism, I would think. I'm somewhat speculating here, but it seems like it might be a bit of a tricky situation for these states.
Well, I think that's the whole point of this decision, right? Is that the states get screwed by supposing that consumers are going to self-report, saying that that's their recourse, and that it at least gives them a somewhat more viable commercial target to go after the businesses than the consumers for the taxes that should be collected on the sale. But I agree with you that small businesses are just sort of one tiny rung up the food chain from the actual consumer, and that they're not it's going to be maybe not as hard to collect from each individual small business as it would be to collect from each individual consumer, but it's still going to be hard. And getting the infrastructure in place and taking into account the fact that people are going to immediately start to, as Lisa calls out, the opportunities for, okay, now how do we deal with this decision? What is the commercial solution to this? Are going to proliferate, and they're not in ways that the states are going to love. So it'll be interesting to see how that all falls out. Any final thoughts, Lisa?
No, I mean, I guess this is a situation where, we have to constantly deal with evolving consumer behavior. And, in theory, the consumers will just pay the tax and the market should, recalibrate. And, I guess I'm interested in how it will apply to online shopping and, whether it's going to change some of the direction of some of the market developments. I'm just thinking of all the, the changing in grocery shopping that we've seen in the last 2 years. And I just wonder if that's going to put the brakes on that or I'm interested to see how it's applied. And I predict they cannot have perfect enforcement. So you're going to have a lot of selective enforcement. And I guess that will be a matter of state policy to determine when and how they go about deciding on auditing or trying to force compliance. I mean, it seems like it would be worth the state's while to go after bigger amounts of taxes rather than smaller amounts of taxes. So I'm just kind of interested in what's sort of the ideal first test case here if you're going to start enforcing.
I wonder if we're going to see legislation related to payment processors or other folks along in the transaction chain here, where state legislatures and taxing authorities are going to try to, require them to somehow collect and remit this tax that's owed on these individual transactions. It seems like there's got to be some sort of centralized process that states are going to have to implement in order to make this effective at all. But
right, and the situation this kind of reminds me of, and what I sort of had in the back of my mind when we started this discussion, is just as it's impossible for rights holders in the entertainment industry to collect for each individual play, or to try and police how they get their royalties, and that's why we have these rights clearinghouses that have developed, and how people can pay a flat fee, and then have the rights to play music, for example. That it really seems like some sort of blanket licensing scheme would help this situation. Of course, there's no licensing involved in the tax situation, but I think you see what I'm getting at. Some sort of clearinghouse where, for a flat fee to the states, which maybe might not completely equal all of the tax that they might otherwise collect, but it's definitely making up for it in the fact that they don't have to do all the collecting. Maybe that would be the way to go.
Yeah, great idea for a referendum in California. I think there are similar things in the small business tax in the state of California. I mean, they have a certain exemption. If you have a small business, and it may or may not depend on whether it's in entertainment or some activity that the state wants to incentivize. I think like the first 100,000 might be exempt from the small business tax or something like that. I mean, that would be valuable, I think, to
Well, definitely. Let us make paying with Bitcoin our first MCLE passphrase for this episode of This Week in Law. We put these phrases into the show in case you are watching or listening to obtain professional credit in your field. If your field is law, we have some information for you. If you are a lawyer in the United States, if you head on over to wiki.twit.tv, find our This Week in Law page there. We have a chart with some guidance for you about your particular jurisdiction and whether there is a way for you to apply to your MCLE oversight board there and perhaps get credit for watching the show. So we'll put another phrase into the show before we conclude. We do this so that you can demonstrate to anyone who needs to know that you actually watched or listened to the show. So let us move on to a decision. Well, I guess we could stick with the Supreme Court as long as we're on the Supreme Court. This is not a decision from the Supreme Court, but we now know one of the cases that the Supreme Court will hear next term when it reconvenes in October will involve Apple's App Store, its iOS App Store. It has granted cert in a case that will that takes on Apple's supposed monopoly in its App Store and comes after it on antitrust grounds. So we don't know what will happen in that case. We know that Apple has been challenged. For example, I believe it was its ebook store that was challenged in a similar way. For having a monopoly and not being open to having obviously third parties are the lifeblood of the App Store. But there's the vetting process. Apple gets to approve or disapprove who gets to be in there, et cetera. So that whole practice is going to get some antitrust scrutiny from the Supreme Court in its next term. Lisa, any thoughts about this?
Yeah, this case doesn't strike me as a particularly compelling antitrust case. I mean, I'm having trouble understanding how they define the relevant market for purpose of claiming that Apple has a monopoly. I mean, in theory, there are multiple competing marketplaces. And my understanding is that once you get approved to be in the Apple Store, they don't actually charge you for being in the Apple Store, but I could be wrong. But I am an Android user, so if something is not available in the Google Play Store, for example, I just think, well, if I felt strongly about it, I would have an iPhone. So I guess I probably will tend to expect that the lower courts, which I understand did not find an antitrust violation, may have the better of this argument.
Right. Yeah, I have a hard time getting my head around this being antitrust too, but I am not an antitrust lawyer, so I will leave it to the esteemed justices at the Supreme Court to decide what they think about it. It will be interesting. It will have a broad impact if the court decides there is some sort of wrongdoing here on Apple's part. I do think that you're correct, Lisa, that there's a lot of at least there's one big significant form of competition, the Google Play Store, right? And I suppose other ecosystems have their own app stores as well, but the Google Play Store operates quite differently than Apple's, and that has its pros and cons. And I think that Apple's going to be able to credibly argue in court that we're not doing this as a monopoly. We're doing this as a good experience for our users, and they have all kinds of reasons why they would say that's the case. So will be one to watch in the fall and ultimately rolling into the spring as it gets argued and decided, like the other cases that we just discussed on the show today. So look for that one coming up on the court's docket next year. And then the other big court decision that's come down in the last couple of weeks was not from the Supreme Court, but from a district court, a trial court, federal trial court in the District of Columbia, which made the decision that AT&T and Time Warner can merge, that this was not going to harm consumers, and let the mergers commence, basically. So we're going to see more consolidation in the telecommunications and entertainment fields as the result of this trial court's decision. It did acknowledge, of course, that this was going to be controversial and that of course, the party, the parties that did not want the merger to take place would appeal the decision. But it did, the trial court did make some statements about now don't harm the market here by seeking a stay of my decision here while you are appealing. So what that means is that by the way, the court just saying don't seek a stay doesn't mean that parties can't seek a stay and that a stay can't be granted, but they are forging ahead with the mergers. And this will definitely have an impact on these fields. And particularly, folks are quite nervous about what this will mean for net neutrality, that the more consolidation there is, the more that players are able to block, slow down, charge fees, build the walls around their gardens even higher. So as we know, too, this is the month that the open internet rules have become defunct. They are no longer in effect. So yet another chess piece moving on the net neutrality chessboard will be these mergers that have happened and will continue to happen. Lisa, any thoughts on this?
Yes.
Yes.
This is a nightmarish week for net neutrality. And then even though we're not going deep into it, that European initiative is super scary. So I expect this will be appealed. In reading the coverage of this opinion, it seems it just brought back the Facebook Senate hearings and realizing that some of these lawmakers are not the most in touch with how these technologies may work or be used. I mean, the idea that because Netflix is out there and earning a lot of money is a reason why there's competition in the broadband world is just sort of mind-blowing in its sort of misunderstanding of the marketplace. So yeah, I was surprised at how pro-merger this judge seems to have been. And I'm very confused. Not confused. I'm very concerned. I'm very concerned about the market power. I mean, anyone who's tried to install Wi-Fi and looked around realizes that there aren't necessarily a lot of options at any given location. And these are players who already have deep monopolies due to the fact that they own the either copper or wire networks. And they have exclusive access from, whatever, fiber to the home or fiber to the node. That there are so many barriers to entering these markets that I'm very concerned at the outcome of this merger.
Yeah, the other thing that was really strange is that the judge arrived at his decision without deciding to put any conditions on the parties as far as trying to preserve any semblance of anything other than laissez-faire, eat your competitors kind of behavior, and eat the consumers right along with them. On this merger, it's not generally the case that something this big would just get the green light without any kind of concessions from the companies merging. So that's not necessarily good. And there was an interesting note from someone at CNET who was interviewed. Let me see if I can find the precise quote. What's his first name? His last name? Oh, Hal Singer. He's an economist and adjunct professor at Georgetown University, who is doubtful that antitrust is going to be the vehicle to block this kind of thing. But he definitely, especially with the net neutrality, the open internet rules going away, he's really hopeful that federal legislation is going to be the way to go. He suggests that amending the Communications Act by adding a new section to require broadband providers and other dominant online platforms like Google and Facebook to offer access in a non-discriminatory way to competitors' content and services is the way to go. And he brings up the 1992 Cable TV Consumer Protection and Competition Act as a model. That's the law that means that cable operators have to carry programming from other cable network owners. They can't just shut them out. So his hope is that ultimately the pressure on Congress will mean, okay, the FCC isn't the appropriate vehicle to regulate, so it has said, and we need to step into this breach. What do you think, Mike?
Yeah, I mean, this is a huge decision. I mean, I agree with your comment at the outset, Denise. I mean, a stay may still issue here by the I guess it would be the federal circuit that this would be appealed to. So this was a 6-week trial.
Might it be the DC circuit? DC Circuit,
the
maybe?
DC Circuit. You're right, because it was pending before the DC District Court. So you're right. I believe it would be the DC Circuit that would hear this appeal. But the thing that struck me is, one, this was a 6-week trial. It was a bench trial, so a jury didn't decide the issue. This was ultimately for the judge to find the facts and kind of weigh the credibility of the evidence and the various witnesses before him. But the thing that I would imagine must have made a fairly significant impact on this judge's decision is that the government's chief economist, expert witness, testified that AT&T consumers are likely to see prices go down as a result of this merger. You always hear about when mergers are being opposed that, look, the consumer's going to lose, prices are going to go up. This is going to be harmful to individual consumers. But the government's witness came to the opposite conclusion. I would think, just not having been part of this at all and just reading news accounts, that would have been a fairly significant concession if I was hearing the evidence from the government that consumers are actually going to benefit in some way with resulting dropping prices as a result of the merger. That's right, pretty significant.
There's a big caveat to that. The prices would drop for a certain suite of content, right? It wouldn't necessarily drop for everything. There would be certain things that you simply just wouldn't be provided access to, or because they're not within the 0 rating bundle that's being offered to you that is at that low price. I mean,
right.
That's how I could see prices dropping. But
that makes sense that you would see prices drop in that regard. But nonetheless, I mean, you still have this testimony that indicated that there was going to be a drop in prices.
Right.
Yeah, I mean, you still, the point is definitely well taken. But at the end of the day, I would imagine that had to figure somewhat prominently in this judge's decision. But it's pretty remarkable that you've got a massive merger like this, and you've got a single judge that's making the determination here. Now, ultimately, it will be appealed, no doubt. But it's pretty amazing that the commercial realities of the marketplace, when you're dealing with a huge merger of two conglomerates like this, that it comes down to the decision of a single judge. Wow. That's pretty amazing.
Yeah. And the appellate process, may be able to undo it, but how would that work? They've gone forward with their merger. They've changed business models. They've shared information. If a court of appeal comes in and says, no, there was error here and you can't merge, I don't know how you unring that bell very effectively. But
very good point.
That's why they need a stay.
Yeah, that's why they need a stay. I commend everyone to Nilay Patel's piece at The Verge titled, "The Court's Decision to Let AT&T and Time Warner Merge is Ridiculously Bad." He goes through and does what we used to call in the blogging world a fisking of the opinion, sort of point by point. Here's what the judge says, and here's why the judge is wrong kind of approach to the case. And I think he's very much in line with what you were saying, Mike, that the judge simply doesn't appreciate the way the internet works, streaming works, these services work. He's conflating. He's thinking that there's some difference in how HBO Now is delivered to you versus how Netflix is delivered to you. That he really just did not have the background to make a reasonable decision here, and that a lot of the conclusions that he's reached are not borne out by how these businesses and these technologies actually work. So there may well be some fertile ground here on appeal if the judge is leaping to conclusions that simply just aren't borne out. So maybe some court will make them try and unring that bell. But for the time being, it's merger frenzy out there. Anything you'd like to add, Lisa?
Oh, that with that Verge article, was that the fisking? Was that the one where he said that Judge Leon sounds downright enthusiastic about the merger?
Yes.
It's pretty entertaining. I recommend it to everyone.
Yes. Absolutely. Mike, any final thoughts on this one?
Nothing further.
All right, and just as another sort of sad note on the net neutrality front, we have been following how the various states have been trying to forge into the breach left by the FCC, and that California was looking to be a leader in that regard. I still, don't count California out, because it still has a net neutrality bill that maybe in this new watered down form is even more likely to pass. But it was going to be a lot stronger until this week. Instead, it went into committee, the Assembly Communications Committee in the state government, and some of its more toothy provisions were removed as the result of lobbying by a group, AT&T, and a group that represents Comcast, Charter, Cox, and other cable companies have been pushing for these changes, and these changes were made. So the bill as amended is still going to ban blocking or throttling unlawful internet traffic and paid prioritization. So it's going to look a lot like the open internet rules that just went away. But there were some stronger provisions that would have specifically addressed zero rating, which wasn't addressed in the open internet rules. They specifically addressed a bandwidth minimum at network interconnection points. If everyone remembers what happened with Netflix in 2013 and 14, that is what that's designed to address. And certain other changes as well that, again, just sort of removed some of the teeth from the bill that net neutrality advocates have been happy to see there. So the bill's still alive. It still has utility, but it's not going to be as strong as it would have been before this week. Any thoughts on this, Mike?
No, I think you summed it up beautifully.
All right, Lisa?
Well, I do think that it's good that California's continuing to lead the way in trying to preserve some form of net neutrality. I was very encouraged that they introduced this bill. Even if it's watered down, it's better than no bill. And I'm optimistic that, all the large companies in the state of California who depend on net neutrality for their business model, you would think with all the profits they're making that they would be able to match the lobbying power of the cell phone providers, but we'll keep an eye on it and see what happens.
Yes, so we had that this week as well. All right, speaking of our businesses in California, let's move on and talk about some developments in the realm of Hollywood, music, and entertainment. Where shall we start? We haven't really talked. I think we've mentioned and touched on the Music Modernization Act. We haven't talked about the fact that there's a bill in the Senate now that challenges it. Why don't you bring us up to speed, Lisa?
Okay, so the field of music copyright is kind of arcane and confusing. And as we all know, the internet revolutionized the way that people distribute and consume music. Speaking of brick and mortar stores, there are no more brick and mortar record stores, not in the sense that we used to have them in the 80s and before. So there's a lot of copyright litigation around music piracy and online distribution, and there's a lot of bitterness in the industry about how the Digital Millennium Copyright Act safe harbor has basically paved the way for businesses like YouTube to essentially distribute music without being subject to copyright infringement cases. So it's been a big problem for a long time. And there's been a divide between the traditional music publishers and distributors and then online businesses that also make listening to music possible and easy. And so there's been a lot of litigation with companies such as Spotify and a lot of speaking out by musical artists and songwriters like Taylor Swift. So a bipartisan bill has been working its way through Congress that's supposed to compromise and bring a little to the table for everyone involved. And that's called the Music Modernization Act. So generally, the Music Modernization Act will sort of solve a lot of the confusing patchwork of different rights that need to be cleared and acquired in order to use music on the internet, and kind of create a one-stop place where someone can basically go get a compulsory license, as I understand, and then they'll pay an agreed rate and they can use it on the internet, and it's a lot easier to comply with music licensing prerequisites. And so the music publishers and songwriters generally support this legislation because it also brings something else that's kind of important to them to the table, which provides a way for songwriters to be guaranteed collection of money for pre-1972 recordings, because there has been some question mark in the law about the different versions of the Copyright Act as it's been amended through time and how that might apply to some of the music licensing schemes. So the big picture is it looked like this was an act that everyone was supporting and everyone was going to benefit from in terms of the rights holders versus the internet platforms versus the songwriters. And I would like to mention there's also one interesting aspect to this act in its current form, which is it's basically provides an amnesty post January 1st, 2008, so that if the act passes, it will retroactively exempt online providers from liability for a certain class of copyright infringement having to do with online music distribution. So it pretty much unanimously passed the House, and then it was the subject of Senate testimony a couple weeks ago, where some very well-known songwriters, I think Smokey Robinson testified, some other people testified in favor of it. And now it was set to be voted on any minute by the Senate, and then it was expected to pass quickly and easily. But there is a competing piece of legislation that has been introduced that could muddy the waters and it could slow it down. So now the future of the Music Modernization Act is somewhat in question. Some people have been attacking it as basically another term extension for copyright and other various criticisms of the act, but we'll have to keep an eye on it and see if this new version of the bill will slow down the momentum that the Music Modernization Act seemed to be enjoying.
Okay, Mike, what do you think about all this?
Yeah, Lisa, in terms of the criticism that it's going to extend copyright, how is that playing out, or how would that play out? Where's the extension component here?
Well, I think that there's some good articles that break down the details, but it has something to do about when certain compositions would have entered the public domain if this act had not passed. So I think it changes some of those events going forward.
Mm-hmm.
Interesting.
All right. Well, we will continue to watch that and keep you all apprised. One thing that we're keeping you apprised on next is this concept of deep fakes, which is either by using AI to generate convincing audio or video, or just a face swapping technology. These are videos that look as though someone is, and I suppose they could be photos too, but really the videos are the compelling things and the potentially quite creepy things if we delve into the realm of adult entertainment. You wind up with a fake video that looks very real that someone was never in. So there has been a lot of discussion, hand-wringing about these are going to be incredibly hard to police and take care of under existing law. And we have a piece in our discussion points for today that was posted at the Lawfare blog, and you can read it and everything else we've referred to in preparing for the show today over at tagpacker.com/user/thisweekinlaw. We're doing episode 427 today. And the notion here is something I believe we've discussed on this show before, that the various states' right of publicity laws might be the way to go, not just to go after the creators of these videos who are, basically like ghosts in the wind. How are you ever going to have a meaningful result against such parties? Number one, they're going to be hard to identify and pin down. And assuming you can do that, is there a there as far as a remedy? But where you really need to be able to target your complaint about something like this, if it should happen to you, is where the video is being hosted, right? So you'd need to go to Twitter or Facebook or wherever else the video is appearing and make sure that there's a way to pull it down. And to have some teeth to claims that you intend to bring against these parties if they aren't going to pull it down, because it's not something that would fall under the DMCA rubric of, oh, you're using my copyrighted work, and so I'm serving you with a DMCA notice, and now you need to take it down, and we can have that discussion of whether there's a reason why it needs to be put back up under the law. This is out of that realm. So there's a piece here by Jesse Lempel, writing at Lawfare about using right of publicity laws for this purpose. And Jesse is optimistic that they could be a sufficient bludgeon for hosting sites to be able to get rid of these things. Now, I think from the perspective of a Twitter or a Facebook or a Google, this is a scary proposition that they need to be responsible for filtering and getting rid of these things. But I think that is something they're just going to have to prepare for, and that this piece by Jesse Lempel provides some of the legal framework as to why that is. Mike, what do you think of this?
Well, I think deepfakes are incredibly scary, and I hope that this doomsday scenario, in terms of them being widespread, doesn't come to pass. I fear that Jesse's probably right, that we're going to see a significant uptick in these. And I think Jesse has a really compelling article there on lawfare.com. I'm not as I'm a little bit more pessimistic about whether right of publicity will get the job done. We've talked about this before. Out of all of the regimes out there, I'd say a right of publicity claim is probably the best one. Mm-hmm. But I think there's some pretty significant obstacles there. I mean, typically, right of publicity statutes and common law developments in the various states require that the person's name, image, or likeness is used for a commercial purpose. Mm-hmm. And it's not clear to me that these deepfakes would be used for any sort of commercial purpose. They could be used for nefarious purposes, embarrassing somebody or doing something else that's untoward. But I'm not sure that qualifies as a commercial purpose. I think Jesse's argument is, well, the individuals that are creating these deepfakes may not be doing it for commercial purposes, but the platforms on which these deepfakes would reside are clearly commercial entities and engaging in commercial conduct in a way that maybe transforms these deepfakes into some sort of commercial activity. But that's a little bit of a one-off for me. At the end of the day, really, this is to a large extent people that are operating in the shadows that pose these deepfakes and do so potentially with impunity. I'm just not sure that write-up publicity. There's some fairly significant obstacles, as I think he references in his article. But it's an interesting proposition, to be sure.
All right, Lisa, this is your field.
Oh yeah, this is why we can't have nice things. There's been many interesting cases that have been exploring the boundaries of Section 230 and, also the safe harbor under DMCA. And I'm just reminded that, this is the kind of thing that causes legislation to nibble away at Section 230. I think we had a recent nibbling away at the harbor for, sex trafficking. So, now no more safe harbor for Craigslist if they're going to post ads for adult escort services. So someone somewhere is going to bring a case about this, and, people are going to see that, this is a super scary possibility, and we may revisit some of the established ideas, I think, about Section 230. Write-up publicity is a very powerful but underutilized and non-uniform body of law. And what struck me on reading Jesse's article was perhaps it's ripe for a national or federal uniform statute, the way we just harmonized all the various trade secret laws. Because as the internet becomes more and more important in people's lives, and if there is a strong public policy, I think, in persons' privacy or right to control their image, then I think there might be a good reason to try to pass a uniform law. But I guess the cases that Jesse had linked to were showing that there are, limits. You can't really, I guess they were saying if it's news or commentary or parody, you can't really call it a commercial use just because someone's advertising against the content. And a trick way to protect your identity, I guess, is go register a copyright in your image, go register a copyright in, a lot of your own videos that would be the base building blocks of any kind of a deep fake of your image, and then you could sue for substantial similarity. But yeah, it is sort of a strange and terrifying prospect. I suppose there are also rights of privacy that you could sue on to try to protect yourself if your identity really was being misappropriated in this way. But again, that's also a matter of state law. There's an unexplored theory under Section 230 that it might not apply if you're seeking only injunctive relief. So it's one thing to try to sue Twitter or Facebook for damages. Clearly, that's treating the platform as the author of the content. But there's a case percolating up through the California Supreme Court called Hassel versus Bird that is basically seeking a ruling to affirm the interim Court of Appeal ruling that you can enjoin a website from continuing to post content if you've gotten a lower court ruling holding that it's defamatory. So by the same token, it seems like you might be able to use theories and then hold the platforms to an injunction. But yeah, it is a very unclear area of law.
Yep, definitely. All right. Well, we will, again, continue to watch the developments in misuse of people's images in these deep fakes. It did seem like there was quite a bit of publicity about them that kind of went quiet there for a while. So I hope we're not just waiting for the other shoe to drop. If we are, the other shoe has definitely dropped for the cable companies because we've already talked a bit about Gen Z and how their devices are just a part of them. They are also completely changing their the way that they consume things like media. Business Insider this week has done a series of articles looking at Generation Z. And one of the things they did was look at their how they're getting delivery of digital entertainment. And they are not watching television in any kind of conventional way that our generation was used to as we grew up. And again, having one in the house, I can completely confirm that this is true in our household, that the only TV my child ever watches is TV that's been recorded on a DVR and is capable of having the ads skipped. And that's, it's generally kind of a family event if we sit down and watch a show that we all like. There is no sitting at the television for my Gen Z son and flipping channels and seeing what's on and finding something and watching the ads. That never, ever happens. Instead, what Business Insider found is that these youngsters are using their devices to select what it is they want to watch. YouTube is absolutely huge in their entertainment consumption realm, as is Netflix and various other services that stream to them largely without ads. So the headline that Business Insider has is, we asked 100 teens how they watch television, and the results should horrify cable companies. So I put this in the show today because our show is old enough that when we first started doing it, we were still discussing ad skipping technologies and challenges to that by various stakeholders in the entertainment industry who were attempting to preserve their business model by being able to assure their advertising that ads were actually being watched. Now we've just gotten to the point where ads are not only being watched, they're being actively avoided at all costs. And we have another interesting piece from Tech Dirt that talks about how broadcasters are attempting to deal with this situation by replacing ads with short inspirational videos instead. I'm not quite sure how that winds up penciling out financially, but the crux here seems to be that as media evolves, so will have to the business models that underlie it, because the days of conventional advertising in programming are either gone or their days are seriously numbered. Any thoughts about this, Mike?
Yeah, I totally agree with the import and take of the article. As having three Generation Zers in our house, I have personal firsthand knowledge as to how they consume content, and the article's exactly right. I mean, It's completely different from how probably the three of us did it, and certainly how the three of us did it as we were growing up. I mean, that's right. I mean, YouTube and other platforms are giving them exactly what they want, and that's where they're going to get their content. It's not going to be through the old, TV cable system. It just isn't. So, I think it's a pretty insightful article.
Yes, and hopefully eye-opening for anyone who's not experiencing it firsthand as we are, Mike. Lisa, what do you think?
I love this article. I like the line it says of the Gen Zers, those who do watch cable television enjoy it largely as a means of bonding with the family, the news, or falling asleep.
Yeah, exactly right. That is so dead on.
It's like let's all go to the old folks' home and watch some cable television for them. But yes. I mean, it is eye-opening, and I do enjoy the way that they talk as they're quoted in this article. And some of those shows that they're watching sound pretty cool. I mean, what I like is the combination of these two articles. I mean, if you are a Gen Zer, why wouldn't you want to spend your time watching a YouTube show from someone who's relatable? You can see into their life. You can actually interact with them in the comment section and on Twitter, as opposed to this like very fake, scripted, self-contained, one-way experience from traditional cable television. And I do think, even though that Tech Dirt article was pretty sarcastic about it, I do think it's time for advertisers to smarten up and realize that one of the main benefits of consuming television on Hulu or on your smartphone or YouTube is the ability to avoid advertising. I mean, we've had lots of technologies and products and services around that, but I do watch both a lot. I watch a lot of cable television, and I also watch a lot of Netflix and YouTube vlogs. And my favorite kind of advertising, well, I do like the Time Warner advertising with the monsters. Those are pretty funny. But I like it. I like it when a company will just buy up all the commercial time and just tell you at intervals, this commercial-free experience has been brought to you by, this company. And I just think, yeah, that serves the same purpose. I have good, warm, fuzzy feelings about that company when they do that. About the unbreakable, inspirational videos, I mean, we'll see. We'll see. I mean, those seem like they could be very easy to parody, but, they probably do have some great stories about some real people. So, yeah, I think this experimentation is good and encouraging, and I like the coverage. I think it's something to pay attention to, but I don't know if you'll ever convince a Gen Zer to pay for cable ever. Well, right, maybe they'll have to now.
Yeah. I mean, I was just going to say our net neutrality discussion plays right in with this, and the changing habits of the younger generation and their media consumption. They're going to want to continue having this experience, and how the business models develop that affect them is exactly what the mergers are about, and what preserving net neutrality or bringing it back are so important to. And, I think that a lot of them get that the flexibility they enjoy. The reason that it's fulfilling for them is that they're in the driver's seat. They're able to pick and choose, and the long tail has gotten so long and so incredibly powerful that they want to remain in the driver's seat of what it is they want to watch. That, my son is a perfect example of someone who seeks out niche programming that only relates to his very specific interests when left to his own devices. So I don't know how you maintain a world where that happens if the AT&Ts and Time Warners of the world are trying to sell you a suite of what they think is going to be palatable to you.
Well, all right, shall we run?
Yeah, go ahead.
So, no, I mean, it's the new rock star. I mean, it's what all the Gen Zers want to be. They want to be YouTube personalities. I guess they just need to get old enough so that they can get elected to Congress and start making their own legislation. But because of our current age limits, it might take a little while.
Well, lots of them can vote. So I think
they need to do that too.
Yeah,
that's right.
The midterm elections are going to be interesting on that front. Let's talk about ticket bots, shall we? Mike, your colleague who was on our show 2 episodes ago, has a post up at your firm's, the TMCA.com blog. Stefan Spada. Am I saying that right?
Spida.
Yes, I'm gonna have to get that name down once and for all. It has a great piece about Ticketmaster, which has been involved in so much interesting internet-related law over the years, and ticket bots and Hamilton, of all things. What's going on here, Mike?
Yes, so this is a great post by Mr. Spida related to this Ticketmaster case that's pending. I think it's in the Central District of California. But it's an interesting copyright-related claim that Ticketmaster came up with. The facts essentially are Ticketmaster going after some of these companies that are essentially creating bots that troll the Ticketmaster website to purchase tickets in bulk and then resell them on the secondary market. So Ticketmaster has been trying a variety of various technological and other legal means to stop this practice. And what it did in this case is that it filed a complaint against various Doe defendants that are launching these bots, and alleged that the act of the bots crawling the Ticketmaster website was an act of copyright infringement. I think the first complaint was dismissed for failure to state a claim of infringement, but upon amending the complaint, the court allowed the copyright claim to go forward. And essentially what Ticketmaster is claiming, as I understand it, is these bots, when they crawl the Ticketmaster website and do their thing, they actually end up copying portions of the web page and some of the underlying HTML code. And as a result, Ticketmaster was able to convince the court that that's an act of copyright infringement potentially, for which these bots can ultimately be liable. So the judge agreed, at least at this point, that Ticketmaster has stated a claim for copyright infringement. So as I understand it, the case is moving forward. So interesting and somewhat novel legal theory that Ticketmaster came up with here.
Yes, much like Lisa was saying, you need to just make sure you have the copyrights in all your videos and photos if you're a celebrity so that you can sue for copyright if you're deep faked. Here, what is it that Ticketmaster exactly is trying to copyright?
Well, so copyright protection extends to websites, and that's not necessarily a super novel concept by any means. And so I'm not entirely sure what was copied by the bots in the process of them going and crawling the site and purchasing the tickets in bulk. It may be that it was just a modest amount of code. I don't really know. I don't have a great grasp of the technological aspect of the copying here. But whatever was copied was sufficient, at least for this court, to say that it's enough, or the allegations were sufficient that you copied something that was protected by copyright, and therefore the case moves forward.
Fascinating. Yeah, so they'd almost have to come back and make some sort of argument like the search companies had to make back in the day, where there's an exemption perhaps carved out for that kind of copying, that it wouldn't be infringement. But these guys aren't exactly providing the public service that someone like a Google was back when it reinvented search. What do you think about all this, Lisa? And tell us about the Bots Act.
Oh, yeah. So first of all, great article by Mike's colleague. I just saw Hamilton in New York, so I really appreciated all the references. So I hope I don't throw my shot away at commenting on this. Okay, so it turns out I have had a matter in the ticketing reselling space, and it is actually incredibly lucrative. I guess the answer to the copyright question is, I think that the way these bots work is that they will foil Ticketmaster's CAPTCHA process they're smart enough that they can generate a way to read the CAPTCHA and then automatically type in the CAPTCHA word. So it seems to me that the theory is, by creating a bot that can process and read and then type back the CAPTCHA, that's the anti-circumvention measure on Ticketmaster's website, that is literal copying of elements of their proprietary site. And then the other comment I wanted to add is that actually very obscure law. The Anti-Bots Act was passed during the Obama regime in 2016. It was effective December 14, 2016, which is unfair and deceptive acts and practices relating to circumvention of ticket access control measures, which is exactly what this is. It's 15 U.S.C. Section 45C. And there are 0 cases that cite this act. And it doesn't create a private right of action, but what it does say is that it shall be unlawful for any person to circumvent a security measure or technological control on a website that sells tickets. So it can be enforced by the FTC or state's attorney general. But in the state of California, that would mean that you could base an unfair competition claim on it per se, because what the allegations are is a per se violation of a clearly established law. So I looked up the case that's the subject of the blog post, the second amended complaint, to see if they were going to try to add this. It seems to me they should. Seems tailor-made for this situation. But in any event, the market of speculative ticket selling and buying is very, very lucrative, and it's not heavily regulated. So I think that this Bots Act is kind of still under the radar, but I imagine it won't be long before somebody realizes that they could, if they could ever prove that a bot was being used, which I guess you could prove through circumstantial evidence, you could have a pretty interesting unfair business practices lawsuit about it in the state of California anyway.
Right. All right. Well, speaking of bots and things that are manipulating other things through various algorithms or intelligence, let's move on and talk about robots and some AI. These first couple of stories, I don't have much to add to. Just wanted to highlight for people that they happened, if they happen to have missed it. Google has gone ahead and enacted some principles for AI use and development that will, it wants to, I guess, continue not to be evil as much as possible. And it has said that it's not going to permit AI under its roof anyway to be used for things like weapons or human rights violations. So they have these it's a bit like the laws of robotics, but it's Google's laws of AI. Be socially beneficial, avoid creating or reinforcing unfair bias, be built and tested for safety, be accountable to people, incorporate privacy, design principles, uphold high standards of scientific excellence, be made available for uses that accord with these principles. So this is a good thing, obviously, that Google is promulgating these principles. And just wonder if either of you have any other thoughts before we talk about a different kind of AI. Mike?
Oh, nothing really. I applaud Google for doing it, though. I think it's great.
Yeah. Again, Lisa?
Absolutely. It's nice to have them be very clear and committed, saying these are not, whatever they said, these are not just guidelines, these are rules. Very different in contrast to the Facebook response to certain inquiries. So I do like this a lot.
Yes. So as comforted as we may be by the fact that Google is promulgating rules and guidelines that seem designed to protect everyone's interests, there's a very fascinating piece that came my way saying, and sort of in response to our show last week about bioethics and reproductive technologies and DNA. This is called "We're Worrying About the Wrong Kind of AI." It's by Mark Buchanan of Bloomberg, and it discusses how the mini brains that biologists are growing in labs are becoming quite capable of doing things. These are brain organoids grown from real cells. And their progress has been so significant that researchers are actually worrying about what to do if a piece of tissue in a lab dish suddenly shows signs of having conscious states or reasoning abilities. So going back to the various scenarios we were considering last week, you can add that maybe the kind of AI that we should have our eyes on isn't something developed by Google, but something developed elsewhere and is more biologically conscious than we thought possible. So just to, give you some fodder for your nightmares for the next little while. Any thoughts, Lisa?
Oh, this was fascinating.
Mm-hmm.
I mean, I do worry about computer-generated AIs. The article is kind of, it's funny the way it reads. I mean, it makes you wonder, why are they developing the brain tissue to mimic those with brain disorders? And, the aim of the research is to better understand psychiatric disorders so you can treat it. But yeah, it does seem to open a Pandora's box. Yeah, it's very futuristic. It's mind-blowing.
It's Abby Normal from Young Frankenstein is what it is. Mike?
Oh, really nothing further other than it's a stunning article, and I highly commend it to everybody. It's really something.
Yeah. All right. One of our listener Gary, followed up on the story that we mentioned where the people were surprised that their Echo device had been listening in and interpreted some of the room conversation that was not directed at the Echo as a command to send a message to someone in their contact list. So part of their conversation got jotted down and then sent because that's how the device interpreted what it heard. So Gary heard that and thought about us as lawyers and our profession and the fact that we are ethically compelled to keep our attorney-client conversations confidential and various other parts of our practice confidential. And just wondered about, what happens when a lawyer has an Echo device in the room? Do they need to be thinking about that? And my answer to Gary is absolutely yes, they need to be thinking about that. But it's really the ABA who develops and the various local bars that develop ethics opinions around this kind of activity. And when it comes down to it, as a practical matter, it's the people who insure lawyers who hold them accountable for their data management practices, and will either not insure them or will provide various insurance rate benefits if they comply with good data hygiene and security practices. But my take, having just filled out my own, renewal of professional liability insurance, is that this kind of a scenario is on no one's radar yet. We do have various statements from the American Bar Association that come out from time to time about really what everyone seems to be concerned with right now is making sure if you're housing confidential data from your clients that you're using good security software, antivirus software, that kind of thing. But having Alexa listen to your conversations is on nobody's radar. So it's on ours now, thanks to listener Gary. And we think that the ABA and various insurance companies will ultimately catch up to the fact that this is something that people should be paying attention to. I don't know about you guys, but I used to commute on a train for work for a while. And I can't tell you how many lawyers I heard yakking away on their cell phones at top volume with their clients that, even though you weren't hearing both sides of the conversation, you knew exactly what that dispute was about and who the opposing party was and what their strategies were, simply if you commuted in the same train car with the person. So this is simply an offshoot of not having confidential communications in non-confidential environments. What do you think, Mike?
No, I agree with you and Gary. This is a very significant issue that people need to be attentive to. And I can speak for myself in terms of how we do it. I mean, we have a whole general counsel's office that deals with these sorts of issues and really tries to stay up on all the latest technological requirements and other technology that can assist and make sure that the client data and information is secured. But it's definitely something that everybody needs to be mindful of.
What do you think, Lisa?
So I don't know if you remember, but like about a year ago, I was listening to the show This Week in Law on my Android phone. I was driving and Emery was talking about Hello Google, and he kept quoting Hello Google in his commentary, and it kept turning on my Google Assistant and interrupting the show.
You're doing it now.
Yeah, probably. And between Google Assistant and Samsung Galaxy, Bixby, super helpful, trying to jump in at every opportunity. Hello, can I help you with something? Yeah, it's very much something that's real, and a big issue. So much insurance has to do with data breach and privacy breach, and it seems like a natural add-on to any lawyer's malpractice policy. But yeah, definitely. I mean, maybe what we need is to institute like a mandatory number of hours of CLE credit just on cybersecurity and privacy, because I imagine there could be a lot of bad outcomes if people aren't up to speed on it.
Yes, exactly. All right. Well, we're going to move on to a trademark story and then close out the show. So I don't know if everyone remembers, but we had a ton of fun featuring the video made by the folks at Velcro TM, the company who don't want you to call their product Velcro. They want you to call it hook and loop. They had their quote unquote singing law department. I don't know if these are professional people hired to portray singing lawyers or if they really are the singing lawyers from the Velcro company. But either way, they're wonderful and they're back. So without further ado, let's just enjoy them, shall we?
Companies made a video telling you that this is hook and loop and not Velcro.
Now we know our message has been heard. Thanks to all your comments and your big colorful words.
Who are all these f***ing clowns? An angry viewer asked us. Kevin says, please hook and loop your heads out of your asses. This guy really hates our lawyers and our trademark rights. Sean, he called us immoral, grasping parasites. Thank you so much for all your feedback.
The worst sound ever.
So glad that you took the time to write.
104 times.
Even though you didn't love the message, lots of you are now getting it right.
As long as you know that it's hook and loop on those store shelves.
It's okay, this English dude wants us to sue ourselves. Fuck the hooks, fuck the loops, Mr. Banana wrote. Hey, at least they said hook and loop together in that quote.
We hear you, people of the world. Thousands of comments from 150 countries as far away as China, where they told us Velcro means powerful hook. And here in America, where they asked us politely to please die of genocide.
Your words mean so much to us, especially those who are constructive, offering other possible names for hook and loop. And here they are.
Friction fuzz.
That's pretty clever.
Click butts.
Oh yeah, whatever.
Fur tape. they call it in Germany.
Kleverschlossen. Kleverschlossen.
Yeah.
Slush.
Kleverschlossen.
Romanian translation. Hedgehog, smell crow.
Yeah, that's awesome, dog.
Root tuber pow.
That has a nice ring.
Woolen claw.
That's marketing.
Grippy grass.
That's not bad.
Thunder scenes.
That's the best one, you guys.
Thank you so much for all your feedback. But look and look, we're gonna stick with it. Hope that you all liked our second video. And don't think it's a forced pile of shit.
Hooray!
Bravo. Bravo.
Bravo. To take your negative YouTube comments and make such beautiful lemonade out of them. There were any way to top the first video. I think they've done it. Especially I love all the suggestions of alternate names because Hook and Loop is a little bit bland. Did you have a favorite, Mike?
I loved every second of that video. I just thought it was so incredibly funny. I mean, who said trademark lawyers aren't a lot of fun, right? I mean, come on. That was just the best. I loved the first video, but the second video, it even topped it. So I can't wait for the third one.
I hope. I don't know. What are they going to make lemonade out of this time? I'm sure that they'll get more colorful comments on their second video. Lisa, any thoughts?
Oh, I love this. I love this the most. So I have a question. So this is the actual Velcro company. So their trademark is Velcro, and they're trying to explain how they don't want non-Velcro equivalents to call it Velcro. So they're suggesting other names for your Velcro type, Velcro-like
yes.
fastener. Okay, got it.
Yes.
Yeah. No, I haven't seen the first one, so I'm definitely going to look it up.
Oh, you should. Yes. Fur tape, friction fuzz, thunder,
scratch.
Thunder,
I like all the
thunder something. Thunder seams.
Yeah, like all the translations.
Yes, indeed. All right. The other thing I thought you might be tickled by, Mike, we haven't spoken since this happened, but the fact that, it was just last weekend when President Trump was meeting with Kim Jong-un and presented a movie, sort of a marketing piece for democracy, if you will. But the movie was, it was credited by an actual existing movie studio that had nothing to do with the White House production that was shown to Kim Jong-un. Destiny Pictures is a real movie studio, but it was in no way, shape, or form involved in the movie that was displayed. So they had a little trademark confusion there, and the likelihood of confusion, Mike, I would think would be very strong. What did you think about that occurrence?
I would think so as well. Absolutely. It was, I watched the video. It was an interesting video, but clearly if I could see people being confused thinking that this was a production of the real Destiny Pictures production company. So
yes,
very, very legitimate complaint.
Right. But because of things like sovereign immunity and because of just bad PR, we're not likely to see a lawsuit about this, correct?
I think that's probably right. And plus this would probably be, I mean, it's really not commercial in nature in that it's proposing a transaction.
Right.
So this is probably one of those instances of a trademark use that wouldn't necessarily qualify as trademark use. I mean, this was really just a propaganda piece, or I'm not sure what you'd want to call it, but it's probably not commercial in nature. So
all right,
Trump's probably safe.
Yes, we'll make Not That Destiny the second MCLE passphrase for this episode of This Week in Law. Any thoughts, Lisa?
I can't believe it's not The Onion. I couldn't believe that video actually came from the White House. Are you sure you're not trolling me?
It's a must. Yes.
It's a must watch.
They've taken to some next level trolling. They really have. Yeah. All I'll say about that. All right, let's go on to our concluding material for the show. Let's start with our resource of the week. And that would be, speaking of other shoes dropping, was it back in the beginning or middle of May that Mark Zuckerberg testified before the Senate, a joint session of the Senate and no, it was the Senate one day and the House the next. That's why I'm thinking he had encounters with both of them. I believe this just applies to the Senate. There were many, many questions asked where Mark answered that we'll get back to you on that one. Those answers are now available and they are 500 pages long. So we have put the lengthy link to them in our discussion points for the show that you can find at tagpacker.com/user/thisweekinlaw. If you want to mine through them all yourself, I have not mined through them all myself yet, but I do think it will make for interesting reading. And I'm glad that Facebook did provide all the answers to the questions that were posed in this one hearing. They're taking a bit of flack for perhaps, ducking, dodging, being politic as opposed to political in their answers. But I think they're probably worth going through and hope to do so myself. And I'm also thinking that there will be another big batch of answers for the hearing in front of the House, that if it's not already available, it will be eventually. So we'll get you the link to that one once we scare it up too. Our tip of the week has to do with the security of your information, just how protected you are if you're using something like WhatsApp or Signal. And if you're thinking that the FBI can't get to that data because of the end-to-end encryption, you might want to think again, which is what Michael Cohen had to do, because the FBI was, in fact, able to get to data that was stored on his BlackBerry using both WhatsApp and Signal. Lisa, did you pay attention to this at all?
Yeah, a little bit. I mean, I read the article, and I never assume anything is securely encrypted. So, it seems like a sort of a naive view to think that something you store on your BlackBerry is not going to be recoverable. But yeah, it is like a pretty astounding amount of material that they did recover, and a relatively small fraction that they were able, Cohen's team was able to assert attorney-client privilege over.
Right. At least he didn't talk in front of his Echo, I guess, is all we can say about that. The FBI was not very forthcoming about, as you might expect, about how exactly they got the material. They simply told the court that's overseeing the investigation that we first told you that our data extraction did not capture content related to encrypted messaging apps. And then they say the FBI has now obtained this material. So I'm sure the security mavens out there can give us their thoughts as to how exactly that happened. We will now conclude our show for you with one of our most favorite parts of the show, our animal selfie of the week. Did you folks know that yesterday was National Selfie Day?
No.
Who declares things National Selfie Day? But this was all over Twitter and elsewhere yesterday that we apparently all agreed it was National Selfie Day. And there is a police department that uses their canine companions in their law enforcement, and they attempted to get a nice smiling selfie with the dog, and instead the dog gave a big old slurp to the officer's ear. We tried to get a canine Stark selfie for National Selfie Day, they have reported, but it didn't go as planned. So this is a true animal selfie. It appears to be, not captured by the animal or at the animal's behest. So I will put that qualifier in that the canine did not instigate the photography, but the photography does seem to have been done by some sort of dash cam in a vehicle. So we could have a debate over who owns the copyright to that particular adorable slurpy doggy ear kiss selfie. But that's our selfie for the week. Any thoughts, Mike?
Well, I always love the end of the show with the selfies. And of course, we know that the ultimate animal selfie case, it may not be dead yet.
Yes.
Because the Ninth Circuit is considering whether it's going to hear it en banc. I don't believe they've reached a conclusion yet. There was briefing that was submitted last week. So the case may continue. Who knows?
It may. And by the time we are back from our summer break, hopefully we will know whether there's any more life in the Ninth Circuit's animal selfie case. We'll let you know, but we are going off on a break. This will be our last show until August 3rd. We will miss you all enormously. We had a great suggestion from listener Jonathan Annett, who always sends me great stuff for the show. He suggests that we ultimately need to do a show about IP rights related to selfies taken by designer pets created using gene splicing techniques developed by AIs on Mars, of course. And I totally agree. And it will be my job to try and put together that show for when we return. So I really appreciate the fact that he's pretty much hit all our favorite bases there. Lisa, it's been so great to see you again. Thank you so much for joining us today.
Oh, thanks for having me on. It's been a blast. Let's not let it get so long to next time. But thanks very much. And thanks, Mike, for being on with me. I do like that animal selfie, but I wonder if there's an animal selfie, do you need probable pause?
Oh. You do now, apparently. Thanks to the Supreme Court. Mike, great chatting with you again.
Oh, it was a blast. Great to be with you, Denise, as always. And Lisa, thanks so much for taking the time. It was a lot of fun.
Yes.
Likewise.
I'm looking forward to getting together with you after our lengthy break, Mike. We hope that everyone takes a nice, good, long summer rest and enjoys the good weather and time with their families. In the meantime, do get in touch with us. Let us know what you thought of this show, other shows, things that come up in your brain as you listen to our shows. Mike is Mike at twit.tv. I'm Denise at twit.tv. Hit us up on Twitter or Facebook. Let us know what's on your mind. Let us know what your dream This Week in Law episode would consist of, other than IP rights, designer pets, gene splicing techniques developed by AIs, etc. We're on down Mars. For it all. Sorry, on Mars. Yes, of course, on Mars. And possibly getting there in the Tesla that was launched by SpaceX would be the only way to make that better. Yes. So let us know who you think we should have on the show, what you think we should discuss on the show, anything you encounter in your media diets, please share with us. If This Week in Law comes to mind as you encounter something out in the wild, we'd really appreciate it. We're going to miss you. It's a long break, but we're going to have some much needed time with family and enjoying of the season. So hope that you have all that too. And we will see you on August 3rd for the next This Week in Law. Until then, please take care.